Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. One of the premises of this program is that political disputes increasingly turn into legal disputes. Not long ago, the court shied away from cases that involved political controversy on the grounds that they presented a political question. That should be resolved through political processes like elections. But starting with the seminal decision of Baker versus Carr, the Supreme Court changed course and decided that only the courts can decide certain political controversies such as redistricting and gerrymandering. Since then, Congress has created more and more areas of government regulation of politics, including campaign finance ethics and lobbying laws, disputes about voting rights, First Amendment association rights, ballot access rules, voter procedure laws, and even national security wind up in court these days. My guest today is someone who, as his official bio states, has observed and written about the, quote, intersection of law and politics. Josh Gerstein is senior legal affairs reporter at POLITICO and has been a reporter for over 20 years, including stints at ABC News and the New York Sun. He has covered political campaigns, the White House, and court cases. Josh, welcome to Early Returns.
Hey, Jan, it's great to be here.
Well, before we get into a recitation of all the wonderful things that are going on in court that you've had the privilege of covering, I think it's helpful to our listeners to know a little more about you. Of course, your official bio is posted on our website as well as on the POLITICO website. But I always like to find out, where my guests grew up and how they wound up in Washington.
Sure. Happy to give you a little rundown on that. And thanks for having me on, Jan. Looking forward to our chat. So I grew up outside of Boston, Massachusetts in a small town called Weston, which is, for people familiar with the area, at the intersection of the Mass Turnpike and Route 128, the big belt road around Boston. And I grew up there. I went to Harvard for college, which is not far from my home. I didn't live at home, but it wasn't too far away. And I wound up in Washington, D.C., actually more than 3 decades ago now, in 1991. My first gig in Washington was as an intern for CNN's investigative unit. It was at a heady time for CNN when Ted Turner thought they would be not only sort of the network of record for the United States, but for the entire world. And he had a vision of deploying sort of investigative journalists to the entire world. It was very, very ambitious. I can say now in retrospect that it was never carried out, certainly not on a global scale. But as a young guy coming out of college interested in journalism, it sounded pretty intriguing to me. So I fetched up at CNN just on the side of Union Station in the brand new building they had just opened up there in 1991 as an intern, and later joined the staff of their investigative unit and ended up spending 3 years working there at CNN. So that's sort of what brought me to Washington. I would not say that I've been in town ever since, but I would say maybe 2/3 of the time since then I've been in Washington. I've had other stints in China and also in the Bay Area of California, the San Francisco area. But for the last, 11 years or so, 12 years, been back here in Washington pretty much full time.
Well, your CNN days would have been just shortly after CNN got everyone's attention covering the protests in Tiananmen Square. I also recall that in the late 80s, they sort of started making people aware of the fact that you could have live coverage from anywhere on the planet, including the protests surrounding the elections in the Philippines when those were going on and so forth. So CNN may not have succeeded in Ted Turner's entire vision, but they certainly were getting the concept down and introducing viewers to what is possible in real time on your television. And of course, now they're competing with Twitter most of the time. Well, how did you wind up getting started in covering legal issues?
Well, I think I've always had an interest in the subject. I was an early adopter, at least in my lifetime, of the Freedom of Information Act. So that gave me at least a passing familiarity with the courts and how they operate. Even when I was in college, I remember taking a media law, First Amendment law class from a professor at the Kennedy School. I believe it was a guy by the name of Scott Matheson. And I think he went on to be both a U.S. attorney and I don't know if he's still a 10th Circuit judge, but he was at least
governor of Utah, I think, at one point.
He may be, or maybe that's his father or brother. I'm not totally sure, but I think he did make it onto the federal bench after his illustrious teaching of me 30 some odd years ago. So those sorts of things. I think I've just always had an interest in the subject. It's not always been my primary assignment. As you mentioned, Jan, I spent a bunch of years, probably a total of more than a decade at ABC and at Politico covering the White House. And so that, the legal system was not my primary assignment. But even when I was doing that, I moved towards subject matters. Those White Houses, both White Houses I covered, or I probably covered 3 or 4, they all end up entangled in the court system in some way or another, whether through an executive privilege litigation or, at least if we go back, an independent counsel investigation, more recently, special counsel investigations. So I always felt some attraction to these subject matters, and I would try to carve off that part of the beat, the more legal part of the beat, for myself. And then I would say for the last 5, 6, 7 years, I've been covering pretty much exclusively legal stuff, either the courts or the Justice Department or some combination of the two. But I've been in Politico for more than a decade now, so always with an eye to what cases are most significant to people active in politics or are most likely to have sort of an impact at a political level.
I think that one of your first cases, which would have preceded your Politico days, was covering a campaign finance case. It involved a fundraiser for the Clinton campaign who was alleged to have violated campaign finance laws. And one of the interesting elements of that case to me was that it was one of the first campaign finance cases where the Department of Justice said it wasn't just a technical violation, which is always handled by the Federal Election Commission. You can get a civil disposition. No, this was a crime. What you, the defendant, did was a crime. And as I recall, you covered that case. How did that work out for the Department of Justice?
Well, in the end, it didn't work out very well because Mr. Rosen was ultimately acquitted. But I'll tell you just a funny upfront anecdote about that. And I mentioned how I was covering White House and political stuff and then a little bit of legal on the side. So as it turns out, in 2000, I was a White House correspondent for ABC at that time. And when you're a producer or a reporter for the networks, there's a rotation and you go out in something called the pool. Sometimes people call it the protective pool or names like that, where you go in the motorcade with the president, wherever the president goes. Sometimes you go into his events if they're going to allow press coverage. And if they don't allow press coverage, often you find yourself sitting in a driveway for what can be a painfully long period of time when the people whose homes the presidents are often raising money at decide to be kind. You'll often be put in a garage or an outhouse or a pool house and left there to your own designs for several hours while the president is hobnobbing with the rich people very close to you where you are. So in this instance, what happened in 2000, in the summer, there was the Democratic National Convention that was happening. And if I remember, I'm trying to remember all the details, but I think so. Hillary Clinton was a candidate for the Senate, I think, at that time. And on one of the nights of the convention, the President Clinton, Bill Clinton, and Hillary Clinton went up to a home in the Hollywood Hills. I don't know the geography of Los Angeles that well. And there was a massive, massive outdoor concert in somebody's backyard. And you had to pay a lot of money to get in. And there were a number of A-list acts that were there. One of them that I remember very, very well was Cher, who sang If You Could Turn Back Time from the stage in a very boisterous delivery. All these events from around 2000 were also somewhat of send-offs for Bill Clinton that Hollywood obviously had a lot of affection for him. So it was somewhat unusual event, very glitzy. I remember it at the time. And I remember Roger Clinton, the president's brother, going on stage and singing, I think I can offer a little opinion here. and say some kind of an atrociously bad song from the stage, but everyone politely clapped, right? Because it's the brother of the president of the United States. And I think he fancied himself a professional singer. Some of the details are fading on me, but I remember it was being roundly mocked, at least among the press corps. So fast forward several years from that event, like it's just sort of an overdone but normal fundraiser. Lo and behold, it turns out that...
And you were at this event?
Yeah, I was there. I was the network pool reporter, I guess, to be there and then go back and report to colleagues, here's what we saw. We would type up something and the video would then be transmitted to all the networks. The White House would not want to have 5 camera crews and 5 reporters at these sorts of events. So I was the pool and, we were there for the evening and then we went out in the vans. So I remember it somewhat clearly, the event. And then a few years later, we find out several people involved with this event are felons. I think the number at the end turned out to be 4, including the main fundraiser who sort of backed it was a guy named Peter Paul, who had been accused of some sort of stock manipulation. And he actually had, I think, 2 felonies on his record at the time of the fundraiser. But I think Clinton lawyer David Kendall would later say he, quote, missed the vet, meaning that somehow, even though he was giving hundreds of thousands of dollars for this event, nobody ran him through Nexus or Lexus or whatever to see if he had any convictions. So it turns out that there's an investigation into the funds in this event, what happened. And at the tail end of that investigation, I think by around 2003, the Justice Department concludes that the fundraising for that event was deliberately misreported. And that, in fact, Mr. Paul and maybe some of his allies had given hundreds of thousands of dollars, maybe it was millions of dollars more than was reported to the FEC. This was, you would know more about this than me, Jan, but this was at a time when soft money was still legal. So you could make very, very large, unlimited, I guess, contributions to national party committees like the DNC or the DSCC. And so why they were lying about how much money was raised has always been kind of murky. I mean, there's an absurdity on a certain level, which is I think that was the last cycle where soft money was allowed. So the whole thing was sort of a moot question by the following cycle. But the situation was apparently that this young man who ended up getting charged, David Rosen, he believed, and some people in the campaign believed, that if they reported too much money coming in, that it would somehow affect a formula that would limit what the campaign could spend in so-called hard money. People did calculations, and I think the conclusion was that in retrospect, this was not actually true, and it really wouldn't have had any significant impact. But the belief in the campaign was that if you reported this guy gave $2 million instead of $300,000, that it would cause problems down the line. And so that therefore they just lied about it on the reports as the budget went out of control for this event. As you can imagine, to bring in Cher and a bunch of other stars was going to cost you more than $300,000. And so this ended up being a criminal case. And the guy left sort of holding the bag at the end of the day was David Rosen. He was in his, I think, early 30s at the time. And he was one of the finance directors for the Clinton for Senate campaign. And he was charged with causing, as I recall, causing false reports to be filed with the FEC. And he said he wasn't guilty of it. And he asked for a trial, and he eventually had a trial in 2005. That's a bit of a backstory, but it is funny that I happened to be there at the actual event that led to this criminal case.
So you were an eyewitness to the fact that this was an extravagant gala.
They should have sworn me in.
Caused you were on notice. It's a good thing you were not on the jury. But as you know, in order for a prosecutor, a criminal prosecutor, to get a conviction, has to have pretty clear and convincing evidence that somebody intentionally committed a crime. And what you just described seems to be a lot of, as Justice Scalia would say, argle-bargle about facts and circumstances and inferences and weird campaign finance rules. Is that what ultimately happened? The jury acquitted this guy and said, it seems to be sincere. Whatever happened here may have been a mistake, but it couldn't possibly be a crime.
Well, so I think what happened, as I best recall, I mentioned that there were 4 different felons who were involved in this trial and this event. There was a weird guy from Chicago who ran a strip club. There was a brother-in-law, believe it or not, of Senator Ted Kennedy. So This had everything in it, but Yul Brynner, as the song
So
goes.
they were all defendants as well as Mr.
No,
Rosen?
they were cooperating witnesses at the
Okay.
trial, right? And so I don't think Mr. Paul testified because he was so encumbered with his convictions that they didn't think they could put him on the stand. But they put these other people on the stand. Ray Reggie, who was Victoria Reggie's brother, gentleman named James, and I'm blanking on his last name, from Chicago, who was a friend of Clinton's, who owned a strip club called like the Pink Pussycat or something in Chicago, something like that. And so several of these people were brought in, and they played an ABC 2020 story with Brian Ross, that just began with the booming music of Cher playing, Can You Turn Back Time or whatever from the stage. And this fellow, Mr. Rosen, I think the main issue with the jury was it just seemed implausible that this respectable looking guy from Chicago, who had been an encyclopedia salesman and was in his early 30s and was sitting there wearing a suit and tie, that somehow, if this event was totally corrupt in the way it was being run, that he orchestrated this and that he ought to bear the responsibility for millions of dollars, and that you have these situations where, Mr. Paul has several convictions that came out, and it was in the story the jury saw. And of course, the cooperating witnesses who went on the stand, the wrongs they had done and why they were cooperating with the government, which went beyond this fundraiser, were all put in front of the jury. And as I said, he was left holding the bag. It just seemed weird that that guy would be the one responsible. Why weren't any of these other people being tried? And could it possibly be the case that it was the mastermind here? And I think the jury just didn't buy it. They heard a lot of testimony from people that there was a deliberate effort to make the expenses seem smaller than they were. The idea that it was intended to sort of trick the FEC, that may also have not flown. But I think it was more the optics of that fellow sitting there by himself at the defense table with this whole plethora of people revolving around on video and on the witness stand, who it seemed to the jury had not been held to account for anything related to this event.
Now, that prosecution would have been brought during President George W. Bush's presidency, right? That was the Bush Department of Justice. Were there any allegations that, this is a Republican prosecution of a Democratic campaign? Why would they bring this case otherwise? Because it doesn't sound like a very good criminal case to bring.
So I don't totally know the answer to that. I do think there was some intimation that that had a political element to it. Of course, DOJ would respond and say, well, this was being prosecuted by the Public Integrity Section, which is basically career, all the way up to the chief of the Public Integrity Section, our career Justice Department prosecutors. So I think that they thought it was a good criminal case because of the involvement of people that candidly should have had no involvement whatsoever with a fundraising event that the president of the United States was at. Just shouldn't have happened. This guy shouldn't have been there. And the Clinton people more or less acknowledged that. They said it was an oversight. And I think that's it. The volume of money involved, if I remember correctly, Mr. Paul ended up fronting maybe more than $1 million for this event because the cost kept going up and up. And Rosen was the guy sort of organizing it on the ground. And, he would get the email saying, sorry, Cher's flight, we thought it was 20 grand for the private jet. Now it's 100 grand or whatever. And he was like, well, what are we going to do? Call Paul and get him to write another check. So he was at the nerve center of all this. But I think there were certainly, he felt like he was being politically persecuted. David Rosen did feel that way, and it did drag out for several years before it actually went to trial. But I don't know, as it turns out, some of the prosecutors turned out to be pretty dyed-in-the-wool Democrats who have gone on to positions in the U.S. Congress or to be very vocal critics of President Trump and signed various letters denouncing things that he did. So it's not the case that everybody involved was motivated with some kind of political vendetta. I know at least one of the prosecutors, and he's an outspoken Clinton supporter. They just thought this event was a bad deal, and this guy deserved to be prosecuted.
Well, President Trump does gain certain bipartisan non-support, I would say. He seems to bring in certain people together in his remarkable career. But subsequent to this Rosen case, there was a perhaps more publicized criminal prosecution that was kind of similar in the sense that it involved private fundraising and who knew what and how did it affect the campaign. And that, of course, was the case involving former Senator John Edwards, who was a vice presidential candidate in 2004, and then in 2008 ran for the Democratic nomination himself. And this would not have political elements in the prosecution, since we're talking about the Obama Justice Department brought a case involving money that he indirectly received. He didn't receive it in person, but apparently his fundraising representatives received money from a very wealthy widow in Virginia who was enamored by his candidacy because she had been a big supporter of President John Kennedy when he ran for president. Senator Edwards apparently reminded her of President Kennedy. And over $1 million was provided, which not only was not reported as campaign contributions, but more significantly was used to defray certain expenses associated with the housing of Senator Edwards's mistress, with whom he is having a very active affair, including birthing a child, right during the 2008 campaign. So the Justice Department said, well, that money that Senator Edwards was active in soliciting, there's no question that he went and visited this wealthy individual and asked her for support, and it ultimately came forward. That's a campaign contribution, and it's a crime. How did that trial turn out?
Well, this one also turned out, maybe it turned out better for the Justice Department than the Rosen one. Rosen was outright acquitted, and at least on several of the counts, most of the counts, I think there was a hung jury for Edwards. I can't remember the tally off the top of my head, but it may have been 10-2 or 8-4 for acquittal or something like that. It didn't go well for the Justice Department. Again, a spectacular story, I think, from a news media point of view because of all the elements, the dramatic elements involved. Of course, it's a sex scandal, so that makes it titillating for people. You know, there was also the element beyond that, sort of the heartbreaking part that he was having this affair while his wife was dying from breast cancer. And then for a while looked like she was getting better. And then she eventually passed away. And so that was another piece to this. There was the fact that Obama apparently personally didn't even really like John Edwards before this whole thing came to light. There was the fact that it did come to light during the campaign that there was allegations in the National Enquirer that he was having an affair. And I think even that he had a quote unquote love child with this woman. And it was vehemently denied by very decent spokespeople for Edwards, one of whom I know fairly well, and other people that worked on that campaign that are very reputable, longtime political people that I would, if they told me something, I would trust them as much as I would trust anybody else in politics, that it was true. Of course, I would add to that caveat, to the best of their knowledge, right? And so it turned out Edwards had lied to a bunch of people in his campaign and denied this, although obviously his fundraiser friend knew about it. And Bunny Mellon, she had an heir to the Listerine fortune or something like that. She knew something about it, although she was in her upper, not mid-90s, I think at the time it happened. So how many details she really knew, I don't know. But it had sort of all the great elements of a tabloid trial. One colleague who works with me at Politico worked at that time for the New York Post, Page 6, and she was sent down to Greensboro, North Carolina, where the trial took place. So it just was a great showdown. It had the moral quality that went along with the legal arguments. Legally, it wasn't the greatest case that the Justice Department was trying to bring. I mean, there were all kinds of problems with the case. One was that, I think when you talk about a trial such as this, there's supposed to be sort of a clear rule that's been violated if you're going to bring a criminal case. And, the FEC actually had a rule that he couldn't have used spent money this way for the campaign because it would have been deemed like an improper personal expense. And there was a written document even where the FEC had said we wouldn't bring a case like this. So it just, to me, seemed like a troubled case from the beginning. I do understand why it was brought, which was that the substantive or or more legitimate reason why it was brought is, again, you have a lot of money flowing to a political candidate or on behalf of a political candidate in the middle of a presidential campaign. Like you said, Jan, more than $1 million unreported. I mean, this is sort of, to me, it evoked memories of the CREEP, the Committee to Reelect the President, and some person with a safe just handing out stacks of $100 bills in the middle of a presidential race. This is, in the Nixon era for the younger folks, when before the Federal Election Campaign Act was passed, and was part of, as I understand it, the motivation for passing it was that people shouldn't just be handing out $10, $50, $100,000 walking around money during a campaign, that maybe someone should write this down, who it came from, report it publicly, and have some rules around it. And it seemed like somebody close to Edwards, and Edwards himself, was essentially giving his back of a hand, if not the middle finger, to the whole federal election campaign system. So I can understand that motivation. Now, there was another perhaps darker motivation here, which was that the U.S. attorney at the time, I believe his name was George Holding, if I remember correctly, and he was contemplating running for Congress. He was a Republican who was held over, I think, into the Obama administration to finish this investigation. And I think people at Main Justice were not so excited about going forward with the case. But he really made pretty clear that if they didn't indict Edwards, he was going to go public, that there was a huge Democratic cover-up. And so I think people must have known it wasn't a slam dunk case to take in front of a jury. But the minds at the Justice Department decided that they would give him permission to indict it.
Well, this could bring us a little closer to home, more recent, because this is reminiscent, is it not, of one of the many issues that President Trump encountered during his 2016 campaign, which was the payment of some money to a woman named Stormy Daniels, who allegedly had an affair or some linkage with candidate Trump. And the money was being paid through Trump's then lawyer, Mr. Cohen, as I recall. And there was this debate. Well, it was during the campaign. Isn't this a political contribution? It wasn't reported. And the payoff money, I forgot where it came from. But there was no prosecution there. And I'm wondering whether that's because some lessons may have been learned from the Edwards campaign case, and perhaps other cases. And my reason for bringing these all up is you've now covered about 15 years of legal disputes involving campaign finance issues that involve candidates and fundraising. And there seems to be an awful lot of ambiguity and inconclusive results from some of the legal theories that have been advanced in encouraging criminal prosecutions of these types of cases, which are much more political than they are legal, and I think the political elements have to be taken into consideration because they will be incorporated in the decision-making by juries in particular. If you bring a case, there has to be some perception that, maybe these disputes are not really legal disputes, that they're kind of political disputes.
Well, there's no question they have political, at a minimum, overtones that the prosecutors and the Justice Department have to think about when they're pursuing them. Now, of course, if you're talking about indicting a sitting president of the United States, that's a whole next level kind of political. Any campaign finance case has some political overtone to it, right? It's somebody's campaign. They may or may not have been implicated, but right, Edwards is political. But if you're going to indict Trump, and it's not quite the case that there was no prosecution of that. What ended up happening, if I remember correctly, is that it was worked into Michael Cohen's plea deal with the government that he admitted that he'd arranged the money, some of which came from Trump, and then money to another woman that came bizarrely. This is our second mention of the National Enquirer in this podcast, but the money for some reason went through a friend of Trump's who was running the National Enquirer to another woman who was making some allegations, sexual allegations about Trump during the campaign. Of course, Trump famously said to reporters on Air Force One he didn't know anything about it. Seems to me it's clear as day that he did know about it. He signed a check for it, and there's other indications he was involved. But Cohen ended up pleading guilty to a crime of arranging an illegal contribution, I think, for both those contributions.
Yeah.
But
that was part of a plea deal by Mr. Cohen that involved many other admitted crimes that had nothing to do with campaigns and politics. He was accused of committing certain types of fraud in connection with getting taxi cab licenses in New York and some other business practices. So there was the impression, I'm not trying to defend him, by the way, I'm just, because this is an interesting element of how these things get ensnared with unrelated legal affairs, these political issues. He was in the soup about some really basic illegal activity that had nothing to do with campaigns. But as part of the deal to admit to those crimes, there clearly was some discussion and negotiation with the prosecutor saying, oh, and by the way, if you admit to these campaign finance charges, then maybe we will recommend a lower sentence when we get to before the judge.
Well, it was a very weird situation, right? Because usually if you're representing a criminal defendant, you'd be looking to minimize the number of things that he or she would admit to. And, if there was a potential innocent explanation for something, or at least a non-criminal explanation, you'd prefer to have that one go in front of the judge than to say he deliberately committed some intentional felony, especially someone as a lawyer like Michael Cohen, right? Who, usually it's hard to prove maybe somebody knew the campaign finance law or didn't. If the person involved is a lawyer, like John Edwards, by the way, is also a lawyer, maybe a little easier to say, well, probably did know what the law was. But you're right, they tacked this on to his plea deal. And I don't think it would have been very hard for prosecutors to convince Michael Cohen's lawyers to add this on. And, people kept saying after that, oh, well, so therefore Trump is guilty and Trump should be prosecuted and maybe he'll be indicted by Mueller or something like this. And I don't know if the statute of limitations is run on this. I suppose it's possible Merrick Garland could decide still to charge Trump with it. But I've never thought it was a great case against Trump because Trump is not a lawyer. And you do run headlong into the exact same argument that was made in the Edwards case, which is I was doing this to prevent embarrassment to myself and to the distress that it was going to cause my wife and the difficulty it would cause in our relationship for this to come out. The same reason I would venture to say most spouses might cover up an extramarital affair. So happened he was running for president at the time. So it had a benefit of on that side. Clearly it would have been not, well, with Trump, you never know. Like maybe it would have inured to his benefit that he had all these conquests or something. It's very hard since people seem to have a double standard for him. But I would think there would be a motivation, both personal and campaign related. And you had the same situation with John Edwards. His wife was in distress and very, very sick. And I'm sure the last thing he wanted was her to find out that he had an affair with a videographer and then that she was living, in hiding in North Carolina somewhere with a child that was his, right? Not a great thing for their marital relationship, which was already under great strain. At the same time, clearly, if reporters were asking about it on the campaign plane, if the answer to those questions was, yes, he does have a love child, that would have been very bad for his campaign. I remember at the trial was also an issue. His campaign wasn't doing particularly well when this issue first came up and in fact cratered within, I think, a matter of weeks. And yet the money kept flowing even after he was out of the race. And this was an issue prosecutors had to also deal with at the trial of, if this was a campaign donation, why did so much of the money go to this woman after John Edwards was not a viable candidate for president anymore? And, they said he might have been attorney general, et cetera, that there were other reasons, but that's not a federal campaign act violation, even if it's politically motivated. So that was yet another way in which this prosecution was hamstrung by the facts in that Edwards case.
Yeah. And in the Trump case, the alleged relationships had occurred, I think, 15 years earlier. So there was a real time disruption in terms of when something happened and how it wound up related to the campaign. All those complications seems to me to make it really, really problematic for a prosecutor to tie this into an unambiguous violation of a campaign finance law. Now, there can always be other violations. I mean, as I said in Watergate, it wasn't the initial crime, it was the cover-up. And we have lots of cases that have been brought in our political, but the charges are mostly about obstruction and lying to the government or FBI agents and investigators. And that kind of, I think, brings us, again, a little closer to now, which is the things that happened during the Trump presidency, which were just remarkable in terms of the number of political and legal disputes that arose during his 4, I would say, short years, but they seem to have been much longer than that with all the things that happened. I mean, you had the Mueller investigation, you had the Paul Manafort, Russia-Ukraine trials, and there's still continuing fallout from that with the Durham investigation, and a president who was impeached and tried not once, but twice. And it's quite remarkable that for the first 200 years of the Republic, we had one impeachment back in the 1860s. But in the last 20 years, 30 years, we've had 3. That seems to sort of reflect the intensity of the political disputes. And any time that it's possible, it not only winds up in court, but it can wind up through the constitutional process of an impeachment if you have control over those parts of government. So what if anything, can we learn from the Mueller experience and Manafort and Russia and that fallout? Does that say something about how the legal process is used these days in fundamentally politically disputed situations?
Well, I mean, I feel like I've had a front row seat to these things for a while because, as I mentioned before, when I arrived in Washington, it was what I would call the era of the independent counsel. I mean, I don't remember how many there were under Bill Clinton, but it was somewhere on the order of a dozen or maybe more than that. And this was, for people that might not know the details, when you had the so-called statutory independent counsel law. It was actually a mechanism where if there was a certain very modest amount of evidence that someone of a certain level might have broken the law, the Attorney General was required to report it, as I recall, to a special panel of the DC Circuit, which would then pick some esteemed attorney in town to serve as independent counsel. And basically, that person would then take as little or as much, usually as much time as he or she desired to explore this issue with an unlimited budget. And I think, conservatives, people like Justice Scalia had been skeptical about this for a long, long time. But of course, in the Clinton era, Democrats were on the business end of these investigations, a couple of which found sort of some modest, what you might regard as modest wrongdoing, many of which turned up nothing and seemed to go on forever and ever and ever. There seemed to be a consensus in Washington by the end of the Clinton presidency, a consensus that wrapped in even such esteemed figures as our current Justice Brett Kavanaugh, that maybe this law was not a great idea. I guess what's kind of fascinating is I think people thought when the law expired, they had put a stake through the heart of sort of freestanding, freewheeling political criminal investigation. And to quote a former presidential candidate, I think it was Steve Forbes, they thought they'd put a stake through its heart, never to rise up and terrorize the American people. And yet, I think we've had some form of this in pretty much every presidency since then, despite the fact that the law went away. These sort of freewheeling prosecutors that get involved in these cases with tremendous political overtones. I covered Pat Fitzgerald's investigation into the CIA Plamegate leak, which resulted in Louis Libby, the Vice President Cheney's chief of staff, being indicted and tried in Washington, D.C. Obviously the most recent example being the Mueller investigation that wrapped up a lot of people, a lot of Washington's bandwidth for a long time. I guess what I would say is that I think I'm pretty sympathetic to one of the arguments that was made against the original law, which is I do feel that when you take investigations and move them from the normal agencies or the normal prosecutors that pursue them, you get results that seem incongruous and somewhat weird. And I do think that while it does seem that Paul Manafort was certainly guilty of some tax violations and various other things, probably also guilty of foreign agent violations, it does seem like the kind of case that if it were held through normal Justice Department channels, could have been resolved in some way, shape, or form without the political show that essentially went on of these, was going to be 2 trials, ended up being just 1 trial, but at which he was convicted on most charges. But his lawyers said, look, if we didn't have these political overtones, we think we could have resolved this case. They never said to me he would have pled guilty to felony tax evasion or a FARA violation, whatever. But I think if he realized the alternative was what he ended up going through, he probably would have. But in this kind of a political situation, I think the prosecutors were looking for more, right? And they felt they had found the president's top man red-handed, and they were going to throw him against a wall. And that's essentially what happened. And I think you see variations of those things happening in a lot of the earlier independent counsel cases where you had people prosecuted sometimes for false statement, violations that don't quite seem like the classic kinds of cases that the Justice Department would bring in a situation removed from any political pressures.
Well, I think the most recent trial that you have observed involved the first prosecution of one of the January 6 rioters, and it was held in district court here in Washington, D.C. There apparently are approximately 800 people who've been charged with various January 6 related crimes of some sort. But this was the first guy who actually wanted to go to a jury. And of course, the event itself was inherently political. I mean, it was a demonstration led by the president in front of the White House, and then they all marched up to the Hill and stormed the Capitol, and several people committed damage and injured police officers and others. What does this episode signify? And why did this guy go to trial? And are there more coming on?
Well, yeah, there's a lot more trials coming, I think. I mean, look, one result in one trial can often be a bellwether, as we see in the civil litigation arena where they have bellwether trials. This could be regarded as a bellwether trial for others who may want to have trials. That said, I think a bunch of them will have trials because, as you said, Jan, this was a political event. And at least some of the people involved want to get the soapbox they think they will have by going on trial. Almost everybody involved probably feels they've been overcharged and they're somehow wronged by the allegations, that were made against them, or that it's been sort of trumped up into what was basically at worst trespassing. They've been charged with something like obstruction of Congress, which is a 20-year felony. And again, I mentioned before sort of the question of whether there's a double standard in political cases, and you're seeing that argument raised again here. These are kind of currently in play, so I'm not going to say whether I agree that there is a double standard, but what I say is at least one federal judge has come out and said he finds it a little strange that the prosecutors are pushing so hard on these January 6 cases when, in his view, people who participated in violence, not in protests, but in violence and property damage related to the protests in Washington the previous summer and spring related to the killing of George Floyd by the police in Minneapolis, the BLM protests. Folks probably remember the showdown in Lafayette Park and the police having sort of a squaring off with protesters there, rather a violent altercation, that those cases haven't been treated as seriously. And we've had a number of the defendants in these January 6 cases come in at sentencing at least and say, look, people charged even with attempting to burn down a federal courthouse in Portland, they seem to have gotten a slap on the wrist or a deferred prosecution agreement or some other fairly lenient resolution. And you want my client to plead guilty to obstruction of Congress, which could carry a 20-year term, or even comparisons to people who disrupted the vote on Brett Kavanaugh's confirmation as Supreme Court justice by shouting in the galleries of the Senate and had to be sort of dragged out, or maybe they walked out. And so, people are trying to deal with this difficult question of how comparable is that to what happened on January 6th. I think A lot of people would say January 6th is sort of sui generis. It's been a long time since anybody tried to interfere in the peaceful transfer of presidential power in the United States. At the same time, someone who was the 753rd person to walk through the doors as the alarms were going off in the Capitol as part of a huge crowd, I think is probably not as culpable as someone who smashed through the doors at the beginning, or if there are indeed people who had plotted in advance of some effort to storm into the Capitol building, how culpable are those people? And then I think you alluded to earlier, Jan, questions remaining about how culpable are others legally or morally or ethically for things they did to stir up people who were already angry. I'm obviously alluding to President Trump or Mayor Rudy Giuliani and the speeches that they gave. We now have a bunch of civil litigation about sort of how foreseeable was it, regardless of what your intent was. You go in front of a crowd that's very, very angry and say, march on up to the Capitol and fight like hell. Are you implying that maybe those people should commit violence? And even if you're not implying that, is there sort of a level of recklessness to go in front of an angry crowd and urge them to do something which makes it far more likely that there's going to be violence? And indeed, there was violence. And there were police officers that were fairly gravely injured. Several committed suicide within days of this. So it's not a trivial event that occurred. But, there's also questions about the First Amendment. And, it's not that uncommon for people to get in front of a microphone at a political rally and say, we need to fight like hell. And do we want to hold people responsible every time you say fight like hell in front of a microphone, that anybody who hears that voice and then goes out and commits an act of violence, which they shouldn't do, and they should know as an individual actor not to do, we're going to hold someone else responsible for using that kind of language? That also seems implausible. But so that's another thing I'm covering in the context, at least right now, of civil litigation over the events of January 6th. And who knows if the Justice Department decides they want to pursue a case like that. Maybe they will. I have my doubts. I don't think they will. But, I'm not so old that I'm not surprised by things from time to time.
Yeah, those legal efforts against Trump personally are interesting to me for many reasons, one of which is that they're so varied. And the January 6th incident raised, first of all, the second impeachment. Next, as part of the impeachment, an allegation was that he engaged in the criminal equivalent of inciting a riot, which is a very problematic legal concept in terms of holding somebody accountable, certainly in the criminal process, for, quote, inciting a riot. I mean, that goes to your First Amendment issues. Anytime that there's something that results in damage or harm to an individual because somebody gave a speech is extremely difficult. And now, currently pending, are private lawsuits, civil lawsuits by individuals. I believe they are Democratic members of the House and others.
Some of the police officers, too.
And some of the police
suing,
officers.
right,
and they claim, look, your speech incited damage to me personally. You have to prove all this. But there has been an initial ruling by a judge that that case can go on.
Yeah, and it's fascinating implications for First Amendment and for political speech, even out of that litigation. I think it was Judge Maida that issued the ruling, who's one of the Obama appointees in the federal court in D.C. And a lot of that turned on, remember, it's a civil case and it's at a very early stage. So it's sort of whether you have a plausible claim. You don't really have to bring forward evidence. You just have to sort of say you have a plausible theory. And one of their theories is that apparently there are recordings where you can hear people in the crowd at the Trump rally on the Ellipse talking about going to the Capitol. I shouldn't say apparently, because I've heard some of these at the Refit trial, talking about going in there, grabbing Nancy Pelosi and dragging her down the steps and letting her head bang, bang, bang on the way down as they rip the members of Congress out of the building. So at least theoretically, if somebody heard someone else talking about doing that and then said to them, well, you ought to go up there and fight like hell, suddenly that sounds like a somewhat different statement than just sort of an abstract call by a political leader for you to be militant in your pursuit of some goal. It sounds more like, you're encouraging someone that's proposed doing something violent to someone else to keep doing that. And I don't think the First Amendment protects that. And so, whether they can prove that Trump, who must have been some distance from these people, heard that they were talking about doing things that were clearly illegal, I don't know. We shall see how that plays out. The president's usually, right, pretty well separated thankfully, from people who are talking about doing crazy, violent things by, at least a couple rings of Secret Service and sometimes by a bulletproof shield or two. So I don't know, but it doesn't take much to say in a suit on information and belief, I think he could hear them. And then where are you? You're going to say, well, no, it's impossible. Well, I can't say it's impossible. And we don't know what his kids told him as he stepped up on stage, or anybody else that was there, or anyone on stage may have said, hey, you might want to tone it down a little because this guy over here is talking about killing everyone. I mean, I don't know. I don't know if that happened or not. And so we'll see.
That's what trials are all about. And when that happens, you're likely going to be there, which leads me to ask, what's it been like covering all these legal trials and cases during COVID? I mean, are you allowed to be there? Do you have to sign in on Zoom, or what's going on, and what's going to happen going forward with the way the courts are going to operate?
So different courts have made sort of different provisions to allow some degree of public access and press access in the days after, March 2020, when basically everything shut down and the Supreme Court announced they were going to do all their arguments on Zoom. And this all happened basically in the course of a weekend in the middle of March 2020. And look, I will say generally, I think that the federal courts and many state courts have done a superb job of allowing for continued public access. I mean, in some respects, it was easy, which is they ended up moving most of their proceedings on Zoom or some other kind of video conference platform. And it's not that hard to give out that link to people to listen or to dial in. And some courts have allowed us to watch them live. Others have said you can listen in by dialing an 800 number. And that's how we've covered most of the January 6th hearings until the last few months. So I don't have a lot of criticism of what has been done up to this point. Obviously, we prefer to be able to watch. Some judges have allowed us to come in and watch the video in the courtroom once the courthouse had sort of reopened. The problem we're starting to encounter now is that some judges are feeling, well, let's immediately go back to the way things used to be, which means the only way you're going to be able to come in is in person. And in some cases, we've seen things actually, in my view, go into retrograde compared to the way they were before the pandemic. And by that, I mean, they're still keeping some of these pandemic measures in place. This was an issue of dispute at the beginning of this Refit trial. They were telling us that for jury selection and indeed for the trial itself, I think we were going to have to just watch a video feed only from some other room in the courthouse. And a number of us said, look, that doesn't seem kosher. And, to just put you there can be problems with those feeds. Sometimes you can't hear the lawyers, especially when there's objections and things like that. And there's almost always some kind of technical issue. And some aspects, it's just not the same as being there. If you're talking about a jury trial, you want to look at the jurors and you want to see if they're awake and who they're paying attention to and who they're making faces at and who they're not making faces at. Do they make eye contact with the defendant when they come in and go out? And those things are more or less almost impossible to do on video. Obviously, completely impossible to do on a phone line where you're listening in. So I view it as a poor substitute. And we're having battles just in the last few weeks with a bunch of judges in different places, one out in Los Angeles very recently involving a trial of a Congressman, Jeff Fortenberry, where similar kinds of complaints that, the public access is being treated as second class. Some of the judges don't seem to give any thought to this. They spend all the time deciding where the plexiglass shields are going to go in the courtroom. And it's somehow an afterthought that the Supreme Court has said that your trial has to be open to the public. And if the press or a member of the defendant's family wants to attend, there's actually a case out of the Supreme Court just a few years ago saying it's a structural error at the trial. And even if the defendant doesn't object, he can later appeal and ask for a new trial because there was no one in the court sitting in the courtroom or someone was denied entry that wanted to observe the trial. Will that stand up in a post-pandemic era? I don't know, but I also don't know why judges would want to mess around with it when there's I think we're at a point in the pandemic where in a trial that might have 30 people in the courtroom between the jury and the participants, that they can squeeze in at least one pool reporter to sit in the corner and make some observations about what's going on. And indeed, to her credit, Judge Friedrich, who handled the Refit trial, after we raised a strenuous objection and actually appeal to the DC Circuit, suddenly the court was able to accommodate 3 observers in the courtroom to watch that trial. So far, I think we're doing okay, but we're waiting to see what happens, for example, at the Supreme Court, whether they continue with live audio of the sessions. A number of us would like to see them put on live video streaming and don't know what the big deal is. But already we're seeing judges at the lower level, especially in criminal cases, say, I don't want any remote viewing of this trial. You got to come and sit on a bench here. So it's actually a matter of substantial contention at the moment between reporters like me who cover the courts and the judges and the court system that, as we come out of the pandemic, how this is all going to be handled.
Just for the benefit of our listeners, I want to point out that your reference, Mr. Refit, is a reference to Guy Refit, who was the defendant in that first trial of the January 6th defendants.
And he was convicted.
And he was convicted of 5 counts, as I recall.
Yes, all counts. Yes.
But not sentenced yet. So it'll be interesting to see what kind of a sentence he receives when the judge gets to that point. Josh, I want to thank you for the enormous amount of time that you've given me to have this interesting discussion. I know how busy you are. I know you've got a lot of trials to cover, and they're not going to let up for the foreseeable future, which means to me that sometime in the future, I might call you and ask you to do a return engagement if you get a break in your schedule. But before I sign off, I do want to ask you the question I ask all my guests at the end, which is whether it's related to law and politics or not. I think people are genuinely interested in what you might be reading, or are there books that you would recommend that you've recently read to our listeners?
Sure. So I don't know if I have actual recommendations, but I did mention that for a couple years I was based in China, and I have sort of a long abiding interest in China. And so the book that I've been reading most recently is, I guess it's an autobiography or a memoir of sorts of a woman. I guess some people would call her a socialite who lived in China I think it was the 1930s and 40s, a woman by the name of Emily Han. And she wrote a bunch of books. I think she also may have been essentially a reporter or a contributor to the New Yorker at one time, sending dispatches in from China. And the book I've been reading from her most recently is called China to Me, which records her several years she spent in Shanghai at the outset of the Second World War and sort of her adventures there as a single woman out and about on the town in sort of what was at that point a very, very chaotic global situation in the backdrop. So it's one of these sort of classic stories where you get somebody's personal interactions and the ups and downs of their personal life laid out against the backdrop of the geopolitical forces of the time, which was really we see history being made now with Ukraine and so forth, but obviously in the late 30s and early 40s in the war in Asia, as part of World War II, you had history being made by the day and real uncertainty in people's individual lives about, where they would be and what they would be doing from one day to another. So I find it's somewhat escapist literature because it has little to do with the stuff that I deal with on a day-to-day basis in court.
And the author is Julian Hahn?
Emily Hahn, H-A-H-N. I think she's got a few different books, but this is the only one that I've actually picked up.
This does remind me of reading the biography of Deng Xiaoping, which was written by one of your Harvard professors, Ezra Vogel.
Yeah.
And much of that book reflects the incredible period of, basically the end of World War I through the rise of China and the death of Mao. And Deng Xiaoping was quite a character in his own right during that period. Josh, again, thank you very much. Thank you for being here on Early Returns. And we look forward to talking with you perhaps again in the future.
Okay, Jan, it's been a pleasure. I'd be happy to do it again.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.